I can't say, I can certainly say I'm not here to praise Lincoln. I'm not here to bury him either. I have always had a more nuanced view, to put it lightly, of Lincoln's time as president. He is, of course, the ultimate icon for the United States, for the world at large. He's the very face of defiance in terms of dividing the nation, but he is also the face of emancipation. And for that reason, we often look over or look beyond the actual legal basis for his actions. Wordsworth once said, when someone wrote about one of his poems, it said, "I really love your poem," and he said, he expressed doubt that he really loved the poem. He said, I think you merely agree with the verse. What he was saying is that you're really not looking at the poem, you just like what it says. The same can be said about Lincoln's legacy. We like the Emancipation Proclamation. We like the unification views of the country. The fact is, however, that Lincoln acted grossly unconstitutionally. He acted not just without authority, he acted in direct violation of the Constitution that he was sworn to uphold. I am not one of those who believes that these are small transgressions that one has to consider in light of the context. Presidents always claim that a given context or emergency gives them license to exceed the Constitution. But when they do so, they don't just become one of the dangers the Constitution is designed to protect, they become the danger that the Constitution is designed to protect against. Now, the interesting thing is that from the very beginning, Lincoln used his considerable legal skills, and they were considerable, to adopt fairly sweeping views of the Constitution. A good example of that is his debate with John Calhoun. I did a piece a long time ago. I actually had to look it up this morning, and I was embarrassed how long ago it was. But he had an interesting debate with John Calhoun. And once again, I have to say with Lincoln, you have to give him credit. He wanted these debates. He engaged in a level of debate in Congress over secession that most presidents would not. He wanted to convince people to lay out his case. And he did it in front of Congress, and the case was magnificently laid out. And it was all Lincoln. This was not the age of speechwriters. Not that any speechwriter could really meet the level of Lincoln himself. But what's often forgotten is the arguments of John Calhoun in opposition. And if you look at John Calhoun's arguments, they are not unreasonable. There is a significant question that existed at that time, whether states could secede from the Union. And if anything, I think Calhoun might have had the better argument, but it was a close one. And the point is that on this issue, you can't criticize Lincoln as much because this is a question that I think was in equipoise. But the funny thing is that people have long kicked John Calhoun into the dustbin of history, and it's once again an example of how the winners write history and the losers are often forgotten. But John Calhoun, for all of his failings, was himself a great orator, a great legal mind, and the arguments against secession were quite solid. In the end, I think many of us might be persuaded by Lincoln. But on these other issues, Lincoln was not arguing issues in equipoise. Even his famed announcements of Emancipation Proclamation that we all celebrate was based on largely a fiction. You know, one of the most memorable lines is that America is dedicated to the proposition that all men are created equal. There's no greater line spoken by a president of the United States. It's also entirely untrue. There are many propositions that we may have been dedicated to since the founding of our country, but equality was certainly not one of them. The presence of slaves throughout our country evidences that equality was hardly a proposition upon which everyone would agree. Lincoln was simply changing the legacy that he had inherited. He had, in many ways, reinvented the republic that he had received in a better image. We would all love to believe that America is dedicated to the proposition that all men are created equal, but we are not as good as our press, as they say, and we're not as good as the Gettysburg Address would have indicated. But the president certainly went forward from the beginning of just before the Civil War in asserting an unconstitutional, actually a routinely consistent unconstitutional assertion of power. That included the calling out of troops, the enlargement of the military, all without congressional authority. He called out the militia to, quote, suppress combinations. Which is an interesting way to put it. Indeed, words meant a lot to Lincoln, and he knew it. He avoided calling this a civil war, even though we always call it a civil war. Lincoln knew better than to call it a civil war. He called it a rebellion because he wanted to suspend habeas corpus. But the writ of habeas corpus is placed clearly in Article 1, Section 9 in the powers of Congress. Now, some, what I would call Lincoln apologists that are quite respected for good reason, like Richard Nelson Current, has written that, well, you know what, the presence of the writ in Article 1 it was really an accident because, quote, they had nowhere else to put it. I have to say I don't subscribe to that. I think it's awfully silly. If you trace the great writ from our predecessors in Great Britain, it made abundant sense for it to be placed in Article 1, but certainly that is how the framers viewed it, in my view. It was without question. But more importantly, there's a consistent line of cases on habeas corpus that made it clear that only Congress can suspend habeas corpus, and those cases preceded Lincoln's action. So the court had already established that only Congress could take this act. But Lincoln was concerned about Maryland in particular. There were many people in Maryland that were Southern sympathizers. Maryland was the key railroad hub, and he needed Maryland as a transfer point, cross point for troops, for resources in order to prosecute the coming war. So he's particularly concerned about Maryland. It's one of the reasons why he ordered or allowed to be ordered the suspension of habeas corpus first in Baltimore and then New York. And then he went further, which gave General Winfield Scott the ability to suspend habeas corpus, including against legislators in Maryland. And so this began in the worst possible way with the arrest of Maryland legislators who simply opposed the war. And when you read the suspension, it is truly shocking that people who, quote, discouraged volunteer enlistment, so simply discouraging people from volunteering, was enough to have you arrested. Disloyal practices, whatever those may be, giving aid and comfort to rebels, were all grounds upon which you could be arrested. And that included John Merryman, who may have in fact been a traitor. But when Merryman went and filed a habeas corpus petition, it ultimately went to Chief Justice Taney, who was, despite some of his more infamous rulings on this, was exceptional. And Taney made clear that the president could not suspend habeas corpus, and in fact issued an order for the appearance of Cadwalder, who was the person that was responsible for incarcerating this individual, to appear before the court. And then there was what I think to be one of the most telling moments during this period, and something that would foreshadow what we see with modern presidents. Because the single marshal that was sent with papers to collect this executive officer stood outside the fort and was not allowed in. And he stood there looking up at this fort where he was told that he would not be able to serve his papers. It was the personification of this conflict, a judicial officer seeking to serve legal and correct papers, and a president who is essentially walled off in a fort. And indeed, the papers were not served. But Taney said quite clearly that, quote, a state of rebellion is the only time when Congress could declare the writ removed, and said that this article is devoted to the legislative department of the United States. It is not the slightest reference to the executive branch. Taney was speaking that there was absolute clarity, and Lincoln knew it. Now, there's a great history here that we can certainly discuss in our Q&A, but my greatest criticism of Lincoln is that he laid the foundation for unchecked presidential powers in wartime. And it is a legacy that is rarely attributed to Lincoln, and one, in my view, that dramatically counterbalances the obvious positive and indeed heroic aspects of Abraham Lincoln's tenure in office. It ultimately blossomed in a very ugly way in World War II under Franklin Delano Roosevelt, who claimed the right to imprison, try, and execute even American citizens without any access to the courts. The case that I'm referring to is In re Quirin, which in my view is one of the most disturbing cases that the court has ever dealt with. It also shows how the Supreme Court is not a particularly good custodian of constitutional rights. This case was based in World War II, the so-called Operation Pastorius. This was an effort of the Nazis to land submarines, 2 of them in the United States, and unleash saboteurs upon the nation. Each of these submarines had teams that were highly trained, had large amounts of explosives. One of them landed at Long Island. 2 of the people in that boat were in fact American citizens, Ernest Peter Berger and Herbert Haupt. But the most interesting character in that boat was the leader, a man by the name of George John Dash. And Dash had secretly viewed the mission as a way of getting the heck out of Nazi Germany. And it turns out that he was planning all along to reveal the operation and to go to the FBI, which he did. Before he did that, by the way, he saved the life of a Coast Guardman who came upon this group of saboteurs bearing their explosives. And the Germans told Dash they had to kill this man. And Dash intervened and stopped them from killing him, and then, rather encryptically, told the Coast Guardman, "Remember my face. Now, basically, get out of here." And so the coastman went and told people about this. And by the way, nothing happened. They basically filed this report, which led Dash to be somewhat curious about why no one was coming by. And so he ended up, believe it or not, going to the FBI and saying, "I'm a German saboteur here to blow up your factories." And they took a report and said, yeah, and sent him along his way. Dash then went and dug up the money, brought it back to the FBI and said, "Look, here's $150,000. Does that show that I am a saboteur? Why would I have this money?" Finally, the FBI believed him, and they proceeded to capture most of the saboteurs. What followed was one of the darkest histories in U.S., darkest chapters of U.S. history. Hoover, John Edgar Hoover, J. Edgar Hoover, claimed that the FBI had found the saboteurs all on their own and eliminated any reference to Dash. He was heralded by FDR, and FDR ordered the men to be executed without a trial. It ultimately led to very brave lawyers going to the Supreme Court, and there they met with what was only gross injustice built on many of these extreme ideas of presidential power. Roosevelt citing Lincoln and others and saying that he has absolute power in wartime, the courts have no power. He had the support of a justice that I would probably say I'm probably one of the leading critics of. I find no redeeming qualities about him, even though law professors seem to love him, and that is Felix Frankfurter. And Felix Frankfurter has almost an absolute perfect score, in my view, of not only some of the worst opinions ever to come out of the Supreme Court, but an absolute absence of any notion of judicial ethics. And Frankfurter met secretly with the Roosevelt administration, helped them plan their case to the Supreme Court, never telling his colleagues. To make matters worse, Murphy on the court actually showed up in an Army uniform for the hearings. It was just incredibly embarrassing. And Frankfurter almost threatened his colleagues to say, Roosevelt, if we say that we have jurisdiction, Roosevelt will simply take these people out and have them shot. So the best thing is just say he has the authority, a rather curious argument to be sure. But it is part of the legacy of Lincoln that these presidents have claimed that in wartime they have near absolute authority. And that, of course, gave full blossom under George Bush in the creation of the enemy combatant statutes. And the notion that the president can build a prison just a few miles off of our shores and deny people due process to try them in military tribunals, even though there are available courts less than 90 miles away. So how does this all then turn out for not just the Constitution, but the citizens at large? It brings me to one of the most curious moments that I have witnessed, and it was at my law school that I graduated from, when Attorney General Holder went to Northwestern to unveil the new policy of the Obama administration, the so-called kill order policy. And Holder proceeded to tell an audience of esteemed judges and law professors that the President of the United States now claimed the authority to kill any of them based on his unilateral authority, period. That the President of the United States has authority to kill any American citizen that he considers to be an imminent threat to the United States. Now you would think in the United States, in this republic, that a president telling an audience of lawyers and judges that he reserved the right to kill any of them would get nothing more than tepid applause. And instead he got a roaring round of applause. It was a bizarre and it was an incredibly unnerving moment. And in my view, it's Lincoln's legacy. That people in that room believed that the President of the United States had the authority to suspend every possible part of the Constitution based on his sole judgment that somebody is a threat to the country, even without a declaration of war. So whatever Lincoln may mean to us historically, I think that he's a far more nuanced and complex figure. And in some ways, it's better for us to see him as he was, extremely flawed. He made the wrong choice. We didn't need the suspension of habeas corpus. What's fascinating is when everyone says Lincoln suspended habeas corpus, they rarely look at the fact that we really didn't have to. And most certainly, he didn't have to do it unilaterally, that Congress would have suspended habeas corpus. And like many excessive uses of executive power, it was completely unnecessary. But what it created, and what it is still maintaining, is a troubling expansion of executive power and an unchecked claim of war powers that plagues this country. In the end, when we are at war, we are fighting for something more than just our security. Security is easy to maintain. We're fighting for something that we believe, a common article of faith, and it's that Constitution. What is odd is that when we go to war, presidents tend to view our Constitution as a weakness instead of the thing we're trying to protect. It is possible to have a constitutional war, and we have proven that over and over again. So let's not necessarily celebrate Lincoln's actions. Let's understand them. But let's at least condemn those actions that exceeded his oath and exceeded the Constitution. Thank you.